Hello, Brian Weeks here again with another MMCD contract consideration. This short video clip will cover the topic of alternative tenders. I want to be clear that although the MMCD uses the terms tender, tenders, tendering, and tenderers, etc., this should be considered synonymous with bid, bidders, bidding, etc. I'll use the terms interchangeably in this video. For convenience, I'll also be referring to the low bidder as the bidder who would be awarded based on the award team's evaluation of all the compliant bids before consideration of alternatives. Typically, in a municipal situation, there will be a policy or perhaps even a bylaw requiring acceptance of the lowest price tendered. Although this is not mandatory in the MMCD regime, the term low bidder is a convenient shorthand for the bidder who would be awarded. The concept of alternative bids has always been challenging for the MMCD Association. Our protocol is a compromise between a strict tender call and a request for proposals. I'll explain why in a minute. In this video, I will be discussing only the standard MMCD instructions to tenderers. The relevant language is in IT 6.2 and 6.3. It is unchanged since it was developed in 1992 and is current into the 2019 edition. The instructions to tenderers form the bulk of the terms of Contract A, which the Supreme Court of Canada determined exists between an owner and every bidder who submits a compliant bid. While owners can write just about anything into these instructions, once the tender closes, they become fully binding on both the owner and the tenderers. I will discuss how our IT6 provides a very limited authority for an owner to consider and negotiate an alternative bid proposal. Through a very broadly worded privilege clause, some owners modify the instructions to tenderers to give themselves much more discretion to evaluate almost anything submitted. I will not be discussing that topic in this video. Likewise, I'll not be discussing the wide-ranging discretion available in requests for proposals. That will be the topic for another video. For this video, I'll be explaining why we wrote IT6 as we did, and what happens if an attractive alternative is offered by the low bidder or by another bidder. Let's start by understanding what IT6 allows and prevents. A tenderer may, at the tenderer's election, submit an alternative tender which varies the materials, products, designs, or equipment from those approved under the contract documents, or approved by the owner as approved equals, as the case may be. But an alternative tender must be in addition to, and not in substitution for, a tender which conforms to the requirements of the contract documents. The critical phrases are underlined. A tenderer which wishes to submit an alternative proposal must also submit a bid that is fully compliant with the tender documents. This is a mandatory requirement. The reason it is mandatory is set out in IT 6.3. The only alternative that the owner may accept is an alternative tender submitted by that tenderer whose conforming tender would have been accepted by the owner in preference to other conforming tenders if no alternative tenders had been invited. This is the compromise I mentioned earlier. Before an owner can consider or accept an alternative, they must have the fallback position of being able to award on the basis of the original design to that bidder. So why would we build in that restriction? Remember that the MMCD is specifically designed to construct municipal infrastructure, mostly below ground. In this limited application, there is rarely a silver bullet solution that the owner or the designer has not already considered and evaluated. The tender design and related documents have been created with the expectation that that's the best way to get the most value for money on the owner's behalf. On the other hand, nobody's crystal ball is perfect. There will be rare times when a bidder has a better idea that was not foreseen by the owner. As an aside, this is one of the reasons for tendering. The owner is looking to get expertise from the contracting community to minimize problems and maximize the benefit of the project. When this happens, the owner does not want to miss the opportunity. So to allow this to happen, we made this singular provision for a great idea to be presented. It does, however, force the bidder with that great idea to take the additional risk of being low bidder to have their idea considered. While we recognize the owner's interest in getting as many good ideas as possible at tender time, we need to protect the bidder's interests too. The MMCD Association is determined to keep this document a clear call for tenders and not a thinly disguised request for proposals. This makes it easier for the award evaluation team to compare submissions on an apples-to-apples basis. It also reassures the tenderers that there is a clearly defined process, mostly based on price, to determine the successful bidder. I mentioned broadly worded privilege clauses earlier. The MMCD Association has been requested several times to expand our privilege clause in IT 15.1 to allow owners more discretion. We have consistently rejected these requests on the basis that they are both unfair to bidders in the short term and detrimental to owners in the long term. So what is the process when an owner receives an apparently attractive proposal from the low bidder? This is the simple case allowed for by IT 6.3. Although IT 6.3 does not specifically mention negotiation, because it allows the owner to accept something different from that required by the tender documents, it can be inferred that some minor adjustments to the contract are permitted. Any such discussions should be limited to getting clarifications on the scope and details of the alternative, as well as considerations for adjusting the terms of the contract to include the alternative. The acceptance of an alternative does not empower the owner to enter into wide-ranging negotiations as if this were a proposal encompassing the entire project. Any changes made prior to award should be limited to those necessary to make the contract documents internally consistent with the accepted alternative. If the owner wants to accept the alternative with substantial changes, the proper course of action is to award on the basis of the alternative as proposed and then adjust it via change orders after award. As always, when in doubt about an owner's rights prior to award, it's best to get legal advice. There is no guarantee that once the alternative is investigated, that the owner will choose to accept it. In that case, the owner must award to the low bidder on the basis of the tendered compliant base bid. As I was editing this video, I realized my last statement could be misinterpreted. There is no obligation for the owner to award at all. If, however, the owner chooses to do so, they must award the base contract to the bidder who proposed the alternative, even though it was not accepted. The owner does not have the right to reject the alternative and then award the base bid to another bidder, because the bidder with the alternative had already been chosen, irrespective of the alternative. Here's a real-life example of the potential risk to a bidder with a better idea submitted as an alternative tender. A municipal tender included a concrete pedestrian overpass. One bidder had recently removed a steel overpass from another site. With some modifications, that steel structure would fit the design location with adequate capacity. The cost of the modified steel overpass would have been significantly lower than building a new concrete overpass. So the bidder tendered a low compliant bid and proposed the steel structure in an alternative tender. The owner entered discussions with the bidder, but eventually decided the ongoing maintenance cost of the steel structure, made the original concrete design the most cost-effective in the long term. The owner then awarded the base contract at the price tendered by the low bidder. The bidder was not happy since they had bid low, confident their alternative would be accepted. Nevertheless, they had to do the work at the price tendered, as those were the tender conditions to which they were committed by Contract A and their bid bond. I suspect the more frequent situation is that a bidder who is not the low bidder offers an attractive alternative tender that the owner would like to consider. Keeping with our intent not to turn the tender call into a call for proposals, IT 6.3 is explicit that the owner is not permitted to accept that alternative. Ignoring IT 6.3 would put the owner into an unsupportable position if the low bidder started a lawsuit claiming breach of Contract A. As I've discussed in other videos, the Supreme Court of Canada has taken a very hard line in this regard, awarding lost profits to wronged low bidders. If the owner is intent on using the alternative idea, then it's time to get competent legal advice on the particular circumstances of the owner's situation. Not only do legal case decisions change the interpretation of the law from time to time, but it is also necessary to determine if the proposed idea is proprietary to the bidder offering it. One of the factors impacting this is whether the instructions to tenderers makes it clear that any information submitted in response to the tender call becomes public information available to all under the BC Freedom of Information and Protection of Privacy Act. Subject to legal advice, I see three possible ways an owner can use an alternative proposed by someone other than the low bidder. First, the owner can award to the low bidder and instruct the CA to immediately generate change orders to incorporate the alternative idea and delete the conflicting requirements from the original design. Obviously, this only works if the alternative is available to the awarded contractor. In the case study I discussed earlier, it is clear that only the bidder with the surplus steel structure would be able to offer that alternative. However, in a situation where, for example, the alternative offered was a different routing of utilities to avoid underground interference, that alternative would be available to all contractors, assuming the owner had, or could get, access to the necessary rights-of-way. The second option is for the owner to cancel the tender call, have the tender documents modified to incorporate the better idea, and then re-tender on the modified basis. Again, this only works if the alternative is available to more than one bidder. When available, this option ensures that the owner gets the benefit of competitive pricing on the alternative. The third option is for the owner to cancel the tender call, have the instructions to tenders modified to give the owner more discretion to accept alternatives from other than the low bidder, and then re-tender with the original design. However, I am certain this option is limited by case law decisions requiring a significant change of scope and/or time delay between the tender offerings. IT6 only allows an owner to accept an alternative if it was proposed by the bidder who would have been accepted on the basis of the required fully compliant base bid. 2. This very restrictive rule is intended to prevent a call for tenders from becoming a request for proposals. 3. Bidders wanting to have their alternative considered must take the additional risk of bidding low enough to be certain they will be the low bidder. If their alternative is not accepted, they will have to do the work at their base price bidding. 4. Subject to current legal advice, owners may have three options to be able to use an alternative proposed by other than the low bidder. A. Award to the low bidder and incorporate the alternative using appropriate change orders. B. Cancel a tender call, modify the tender documents to incorporate the alternative and re-tender on the new basis. Or C. Cancel the tender call, modify IT6 or IT 15.1 to allow the owner more discretion to accept attractive alternatives from other than the low bidder, and then re-tender on that basis. I hope this has helped clarify this contract consideration. Please check our website for further assistance and to see what other topics are presented in this series. Thanks for watching.